Ladies and gentlemen and ladies and introducing the most stupendous, the greatest ever, the most brilliant, the most extremely talented of all time. Well, anyway, ladies and gentlemen, we gotta have a conversation. We showed you some time ago that contracts are property. Now, isn't it interesting that under the Fifth Amendment of the United States Constitution, your property cannot be taken away from you without just compensation? Well, guess what? Congress is trying to take away your property. What are you talking about? They already took away all property. All property in the United States belongs to the United States. You know that. No, 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 no. Not that property. A different property. Because Congress wants to play the thief. So, watch this. We're going to type in the Fair Arbitration Act. You heard of the Fair Arbitration Act? Well, the Fair Arbitration Act is, well, watch this. We're not talking about the Fair Act. We're talking about the Fair Arbitration Act of 2019. That's right. They're trying to pass it, and see, Fair Act seeks into mandatory arbitration agreements. No, it doesn't. Don't believe that. Do not believe that it seeks an end to mandatory arbitration agreements. Can Congress enforce arbitrations? There is no such thing as a mandatory arbitration agreement. But with the Fair Act, you see, Forced Arbitration and Justice Repeal Act, FAIR. This is not about, let's go ahead and read about this Fair Arbitration Act. Let's go ahead and take a look and see how much fair this junk really is. The Fair Arbitration Act works this way, everyone. If you bring a challenge against the government, the United States government or any government agency such as a federal prison, you cannot use arbitration. You have to pay attention to this. You have to then go through the court system. Oh my goodness. That's right. That's the situation. Now it says identifies forced arbitration as one of the top threats to real justice in its 2018 report. Our country, our courts. Look, Earth Justice identifies arbitration as one of the top threats to real justice. Really? Because it takes the power away from the courts. Sorry. Boing.net. I guess that's a name of a website. The Fair Act to end forced arbitration, employment, consumer, antitrust, and civil rights dispute. See, civil rights. You cannot bring a civil rights dispute to arbitration. That's what the Fair Arbitration Act is trying to do. Here's the problem. The arbitration agreement is a contract between you and government. Pay attention. They're trying to call it forced arbitration as if somebody is forced to go through arbitration. No, what they mean by forced arbitration is the fact that you signed an agreement and now you have agreed to go to arbitration as opposed to the court. You waived your right to go to the court and you've elected to go to arbitration. That's not forced, but they're calling it being forced. That's the advertisement. Why are they advertising it this way? Because they need to sell it. Okay? Pay attention. I want you to follow this. As land, contracts, intangible property, and personal injury can create a cognizable taking claim. Insurance contracts recognize property under common law are property under the taking clause. I don't know what the taking clause is. Y'all know what the taking clause is? I heard of the ticking clause and I heard of the Santa Claus, but I never heard of no taking clause. So, the Foreign Sovereign Immunities Act and the Fifth Amendment. Ladies and gentlemen, contracts are property. The government cannot interfere with contract. They cannot impede the obligation of contract. And if one of those obligations of the contract, especially if it doesn't violate public policy, is that the individuals utilize arbitration, which is a recognized, cognizable common law right, then they got no choice. Hey, Egypt, Air Flight 648. was hijacked on November 23, 1985. 58 of the 98 passengers died. Oh my goodness. 3 years later, Pan Am Flight 103 exploded over Lockerbie. I remember the Lockerbie, Scotland Pan Am flight when the airline was called Pan Am. Yeah, that flight pretty much took them out of business. All 259 passengers died. Now, advancing the novel taking theory, the plaintiffs in aviation and General Insurance Company, Ltd., versus United States. Insurance companies and an asset management company asserted that President George W. Bush restoration of sovereign immunity to Libya in 2008 constituted an unconstitutional taking of their property interests in insurance contracts. Technically, that's correct, but however, here's the thing. Libya was a sovereign country. You couldn't sue the country, not unless the sovereign waives this right, even under international law. Libya was not responsible for the downing of the plane. It was extremists, or it was the United States government, or it was the CIA, or it was Massa, or it was this, M5, MI6, and BMT, AMW, and Volkswagen. It was one of them, but Libya is a sovereign nation. Judge Willer granted the defendant's motion for summary judgment on July 7, 2016. Why? Because Libya is a sovereign country. You cannot get around the sovereignty of another country. It doesn't matter what the Foreign Sovereign Immunities Act is. However, here's the one way you get around the Foreign Sovereign Immunities Act, is if the government entered into a contract with you. Then they waive their sovereignty. Let's continue to read, shall we? Because you need to understand. This post describes the legal background of the case and the court's opinion. It also discusses how the Aviation General Insurance Company should be a warning to clients and attorneys considering filing a takings claim. First, alternative method to framing the taking claim, it should be called a ticking claim anyway, may increase the likelihood of overcoming summary judgment. Second, litigants and lawyers may use taking claims as a strategic part of their larger litigation plan. Hey, that's what I'm talking about. Now, that's what I'm talking about. No, that's what I'm talking about, everyone. This is all a huge thing. It's not just a one-person thing. A lot of people have been looking at this arbitration thing as one-sided. So let's look at the statutory background. We only got a couple of minutes because I got a meeting and I have to be on in a moment. Statutory background: 1976, Congress passed and the President signed the Foreign Sovereign Immunities Act. Foreign Sovereign Immunities Act, pay attention, ladies and gentlemen, has been around since 1933. You just need to understand. Designed to codify Congress's finding of the determination by the United States courts of a claim of foreign states to immunity from the jurisdiction of such courts would serve in the interest of justice and would protect the rights of both foreign states and litigants in the United States courts. Ladies and gentlemen, that's not the reason why they did it. They did it so that they could have leverage over these other countries, so that they could have diplomatic immunity. See, the Foreign Sovereign Immunities Act cannot topple diplomatic immunity. Diplomats of other countries have immunity, which means that the other countries have immunity. Sorry, international law. At its core, not United States statute, the Act provides that a foreign state shall be immune from the jurisdiction of the courts of the United States and of the states. Not true. Not true. Go ahead and look at the foreign leaders, like the leader of Libya, Muammar Gaddafi. He was the leader of Libya during the time of the Lockerbie plane crash. That's how they built up so much hate against him. But he was an ally of the United States. And look at how they went after him, and look at how they toppled Libya. Subjects of various statutory exceptions that FESA described in detail. The Foreign Sovereign Immunities Act, by the way, is what the FSIA stands for. In 1996, Congress added the exception to the Foreign Sovereign Immunities Act, general grant of foreign sovereign immunity, that gave the United States courts jurisdiction over civil suits against state sponsors of terrorism filed by U.S. victims of terrorism. Or could it be that the United States is committing an act of terror against you? Let's continue. In the early example of the application of this exception, a father was held to have jurisdiction to sue the Islamic Republic of Iran for the death of his daughter at the hands of state-sponsored terrorists. Ladies and gentlemen, if you're in a country and one of your citizens decided that they wanted to go to a different country and kill somebody, they're saying that they can hold your country responsible for that because they'll say it's state sponsored. Who determines whether it's state sponsored or not? Interesting, ain't it? Libya was designated as a state sponsor of terror under Section 1607A7 on January 28, 2008. Plaintiffs filed a suit shortly after. On August 2008, Congress passed the Libyan Claims Restoration Act, which removed jurisdiction over Libya's terrorism-related cases. Yes, it removed jurisdiction. No more jurisdiction. Can't sue Libya no more. That's what they did. Pay attention. President Bush then issued an executive order which officially recognized the settlement of outstanding claims against Libya and stated that pending United States District Court suits against Libya would be should be terminated. The government of Libya paid $1.5 billion to the United States in order to provide immediate and fair compensation to United States nationals with terrorism-related claims against it. The Foreign Claims Settlement Commission, however, found that the plaintiffs' foreign companies were ineligible for compensation. Oh my goodness. They made Libya pay 1.5 million and nobody got any of that money? Regulatory takings. The courts have taken two approaches in assessing whether a regulatory taking has occurred. The Penn Central Multifactorial Test is, and the Lucas Categorical Test under Penn Central. The court determined whether a taking has occurred based on three considerations: the character of the government action, the extent of the regulation that interferes with distinct investment-backed expectations, and the economic impact of the regulation. Under the Lucas standard, a taking has unquestionably occurred where regulation denies all economic beneficial and or productive use of the property. Ladies and gentlemen, I didn't know about the Taking Act until now, and that's what Congress is going to have to deal with if they try to prevent people from utilizing the right to arbitration. So, we got to go back to opinion, and all of you can start doing some research on the Taking Act and get things going. See how this thing is just running? I ain't running. I'm trying to get to the opinion. The plaintiffs have a property interest in the insurance contract. As I told you, the moment Congress steps in, they'll be interfering with the government's right to contract it. Well, we're not interfering with it. We're just saying if the parties have a problem, they can go to the courts. No. It's a private contract between private parties because the government has abandoned its sovereign capacity. They can no longer be treated as government. See, that's the whole point. This is what I want you guys to get before I shut down this video and start doing my business in my meeting tonight. Ladies and gentlemen, that's the point that nobody's getting. The moment government enters into an agreement, any type of contract, they're waiving sovereign immunity. Why? Because government has the right to be sovereign. So they don't have to enter into a contract with anybody. The only way they can enter into a contract is that they have to give up some of their authority. They have to agree to something. Well, they're government. Government doesn't have to agree to anything, but they do. And because they do agree to something, that means that they've waived their sovereign immunity. They're no longer government, can't be treated like government. I want you to pay attention now. With that being said, so all of y'all can know, when Congress makes an attempt to do what they're trying to do, they're going to run into the problem where people are going to have contracts with the government. They're not going to be able to get out of those contracts with the government. Congress is not going to be able to stop the individuals from going to arbitration with contracts against the government. They'll use the courts to take care of that, but they won't be able to because the argument you will bring is that the government, when they entered into the contract, they did so as a private party and not as a sovereign party. They waived their sovereign immunity because this contract involves commerce, and anytime the government gets itself involved in commerce, they waive their sovereign immunity and shall be treated as any other corporation. You just need to understand that's what is holding Congress up right now because they can't get around that. They cannot interfere with government's right to contract. because that's exactly what they'll be doing. And you can bring a claim on behalf of the government saying that they're interfering with government's right to contract. You bring a relator claim. Okay, now they'll do everything in their power to stop this, but enough of you bring it, and the right person, eventually the right person's going to do what the right person needs to do, and that's going to kill everything. They ain't got no control after that. All right, ladies and gentlemen, ladies, I do have to go, but I just wanted to let you guys know that you don't have to worry about Congress passing this new law, because as you saw here, the Taking Act, that should be, well, it's called our property under the Takings Clause. I don't know what the Takings Clause is, never seen it, but hey, now it's time for us to do some research, hey? Gotta go. Gotta have a nice day. Ladies and gentlemen, under 16 minutes. I guess we ain't takings no more, 'cause I done takings all I can stand till I can't takes no more. Gotta go.